Hi, Andrew Pfeiffer here from Pfeiffer Law in Akron, Ohio again. Today, I'm going to be talking a little bit about the real estate law portion of my practice. I really enjoy real estate, come from a very real estate involved family. We've bought and sold some properties and done Section 8 housing. I've had a college rental myself before. I've got a duplex that I own now, and we've done a bit of commercial investment as well over the years. And so I really enjoy working with my real estate investor clients, both to look at protecting their assets, asset protection while we're growing our portfolios, eventually looping that and tying that into our estate plan and saying, how do we get this stuff down generationally? Today, I want to talk a little bit about owner financing, right? This comes up in the context of we're trying to get away from a bank for some reason or another. We want to avoid maybe the interest rates that banks are charging for loans. Maybe the credit that we need isn't there. Maybe the history of income on the business entity or individually isn't there at the time. And so we're going to the owner directly and we're saying, hey, can we negotiate a purchase structure with you that allows us to let you act as the bank and us to borrow from you and then eventually buy? Now, the two most common forms that we see are land sale contracts and leases with an option to purchase. Now, these are very similar in some ways in that they both start out as a sort of hybrid landlord-tenant-like relationship, but the land sale contract does morph a bit, and we'll talk about that. The lease with the option to purchase stays pretty traditional landlord-tenant until the end of the term or when the option period occurs. And what I want you to understand about land sale contracts is that they're a creature of statute. So there is Ohio Revised Code sections that cover what is a valid land sale contract and also, what happens when a person that's entered into a land sale contract pays for the greater of 5 years or more than 20% of the purchase price. And what the law in Ohio says is, at that point, you're not treated just like a tenant anymore. You've got enough skin in the game that you get a bit of possessory ownership interest in the property. And so instead of being evicted, you now have to be foreclosed against. And so it's good if you're under a land sale contract to understand that there are some key points in time or value where you aren't just a normal tenant anymore. You're becoming, in the eyes of a law, a bit of an owner. That's not the case for leases with an option to purchase. What we typically see there is someone is paying additional consideration up front, and the lease may say that a portion of the payment each month is going towards or to be set aside towards a down payment or towards purchase price eventually. But ultimately, there's an option period, right? And you can exercise that option either by paying money and executing in writing to the owner that you are going to exercise the option and purchase per the terms of the agreement. Or maybe you paid additional consideration up front and you want to exercise that option now. I think that these are great options in some circumstances for folks that just don't want to deal with a bank for whatever reason that may be, or they want to negotiate. Perhaps they feel like they can get a property for fair market value of what a seller is willing to sell and maybe negotiate themselves a better interest rate under an owner financed option than they might get going through traditional financing. But in either event, I enjoy my opportunities to draft land sale contracts and leases with an option to purchase and to work with my investor clients as they seek to grow their real estate portfolios. Thanks so much.